topic for the presentation is Research and HIPAA Privacy Protections, and it's by Maria, Carolyn, and Kenzie.
Okay, so for the learning objectives with this module, it's going to be to summarize HIPAA's additional privacy protections for individually identifiable health data that's used for research with any human subjects, and it also talks about the authorizations and accountings of disclosures as well. The second objective was to describe situations where full HIPAA privacy protections are needed and where you can get waivers, alterations, or exemptions from HIPAA privacy protections with different requirements. And then the final objective was to explain the responsibilities of researchers and organizations for meeting HIPAA's privacy requirements and appropriate data security protections that are necessary to protect privacy if technology is being used for research. So, just a quick overview of what HIPAA is. HIPAA stands for the Health Insurance Portability and Accountability Act. It was passed by Congress in 1996. And overall, to simplify it, it just prevents medical and personal information from being shared without the patient's consent. So, this can be in a healthcare setting between a patient and their provider or their care team, or it can be in a research setting with human subjects. So, who's protected under HIPAA? Any members of the workforce that are covered under the insurance policy are protected by HIPAA. Any business associates that work with that company, in some cases, are also protected by HIPAA. And then, in the case of research, it would be the researchers or the healthcare providers that are providing care to the patient. So, HIPAA in research specifically, the important thing to know is how HIPAA defines research, because this is what warrants whether or not exemptions or further applications are needed. So they define it as systematic investigation, including research development, testing, and evaluation, designed to develop and contribute to generalizable knowledge. So all subjects should be informed about HIPAA protections that are in place that are available to them in research. And then also, if there is any issues, all subjects should be given the resources to file any complaints if they feel like there's anything going on that shouldn't be going on with their privacy. So here's some of the general rules. So there's 3 different situations when authorization is needed. That's when you have pertinent health information being used. So anything that identifies a patient, their name, date of birth, and things like that. And then if the research project meets the definition of research that I mentioned in the previous slide, then you're going to need HIPAA authorization. You don't need HIPAA authorization if the research involves minimal risk. And by risk, they mean risk of information being breached. And then research is used to prepare for other research. So if this is just leading to another project, authorization may not be needed. And then information from deceased individuals is used, but there does have to be confirmation that the individual's information being shared are actually deceased. And then if the research is in place before HIPAA was in effect. If the data can't identify an individual, you don't need HIPAA authorization, but you need to ensure that fully de-identified data is being used, so nothing to identify the subject themselves, and that limited data sets are used with a data use agreement, so different than the HIPAA authorization.
So, who enforces the HIPAA protections? Everyone that is involved in research or in a healthcare setting is supposed to know and follow the rules and regulations that are stated underneath of the HIPAA overarching topic. For disciplinary actions and issues, the IRB, specifically for research, assesses the compliance for things such as the FDA regulations, ensuring that the common rule requirements are being followed, and that all HIPAA research requirements are also being followed. The entities that are covered under HIPAA are allowed to make privacy boards to ensure that HIPAA rules and regulations are being followed. This is just to allow for further understanding that there are rules and regulations and that smaller entities are able to have disciplinary action under this. And then research subjects also have rights under HIPAA, and they have the right to report to organizations and authorities at federal and state levels to report issues or things that they think are not being followed through HIPAA. So HIPAA was just enacted in 1996. So there was time before that without HIPAA. As Maria stated, there were, if research was conducted before HIPAA, then different rules and regulations apply for that. When there was research being done before HIPAA was instated, there was no health privacy law or federal limits on the information sharing. So with that, they could give medical records to your employer. They would post records in the newspaper, and every hospital and insurance company used their own unique paperwork and claim codes so that it would be affecting how billing occurred. So there was no standardized billing codes, and there was also no right to consent. So all those forms that you fill out at the doctor's office now or in any medical settings or prior to research, those were not a thing, and the researchers had the opportunity to do whatever they wanted to do with that information and personal health information. So an important part of research now is de-identification. So researchers must have all direct and indirect identifiers removed so that it's no longer considered protected health information. They want to eliminate or at least make it highly improbable to be able to re-identify using statistical techniques. After this is completed, it is no longer considered personal protected health information because by definition, it is no longer identifiable to the individual. And then guidance regarding for de-identification of protected health information in 2012 is guides that provide detailed descriptions of alternative methods and should be considered required reading for anybody completing a de-identification strategy. And with this, the risk is never zero with de-identification, but the requirement is that the risk is identified as very small to ensure that these records are not get leaked into the wrong hands of individuals. Going along with de-identification, there are limited data set agreements. So de-identification trades privacy protection for productivity. So with this, removing too much of the protected health information can make it less useful for research. So all direct identifiers being removed, but it may still include information that could indirectly identify subjects using the statistical methods. When you remove too much data, if it then becomes unuseful and the data is no longer useful because of the removal of these protected health information, then it's no longer a viable data source anymore. So they may disclose some protected health information in a limited data set, and the researcher must be in the data use agreement to be able to do this. So all direct identifiers must be removed, but they can have a limited set of identifiers to ensure the research is still being applicable and used with these identifiers. So anybody that is using the limited data set use agreement must delineate the permitted uses and disclosures of such information by the recipient consistent with the purpose of the research. So with this, only the data that is necessary for the research is allowed to be used. Number two, limit the individuals that can use or receive the data. So only respected, trusted individuals that are conducting the research are able to have access to this information. And then number three, require the recipient to agree not to re-identify the data or contact the individual. So with that, they need to still fall underneath the HIPAA to ensure that this person is still protected. So minimum necessary use and disclosure. The minimum necessary standard is for uses and minimum that is no more than minimum risk that is required for the research. The information that is obtained using the authorization is not bound. So, by contrast, research information obtained using the authorization is not bound by the minimum necessary standard on the theory that the data subject has given explicit permission in accordance with the signed authorization. However, it is important to be aware that while HIPAA may not require a minimum necessary justification at all times, an IRB's evaluation of the risks and burdens on human research arguably does. So, making sure that the IRB evaluates the risks and burdens are still required underneath the minimum necessary use and disclosure.
So Maria talked a little bit about when an authorization is needed versus when it's not needed. But just to talk about what an authorization looks like, it must be in plain language in writing, and the specific PHI being disclosed must be thoroughly described. It must state if there is a specific research study or if it will be utilized for future research, and then this changes the deadline of how long the authorization goes for. Additionally, it can be revoked by the subject at any point unless there was a revocation signed, and a revocation essentially indicates that the future disclosures of HPI will not occur, but does not prevent the current HPI from being released. Recruitment methods are defined as methods used to identify potential research subjects or to draw potential research subjects' attention in participation in research, including but not limited to identification through records review, in-person discussion, and the use of recruitment materials. Recruitment into research for those in which involvement is appropriate. So, for example, a doctor is allowed to discuss it with one of their patients that they feel that the study would be fit. But to recruit for research, you must describe the plan and the protocol for recruitment, and that plan for recruitment has to be approved by the IRB. The IRBs have policies regarding the entire recruitment and screening process that encompass the Common Rule, FDA, and HIPAA requirements. Retrospective research involves evaluating past data to look for patterns. So the use of PHI for retrospective research must be done with a patient authorization, a waiver, an alteration, or exception from the IRB. It is important to remember that as society, as we progress technologically, patient privacy must still be upheld. The security rule is designed to complement the privacy rule, and for those two to encompass HIPAA, dictated by this picture below. But the security rule requires that PHI collected in research is given the appropriate security protections. Individuals working in research must be properly trained. The devices need to be protected, and data transfers must be secure in order to follow the security rule. The case study that we did regards an oncologist that was interested in conducting a research study evaluating the correlation of patient smoking history with the development and treatment of different types of pancreatic cancer. She proposes to have patients be admitted to the hospital for treatment of their pancreatic cancer, complete a detailed questionnaire regarding their smoking habits, and she would have the access to the patient's medical records over 5 years for information concerning cancer type, treatment, and survival. So if we take a look at the breakdown of this case study, the oncologist is asking a patient to fill out a questionnaire without detailing what the information will be used for, which is not ethical and violates HIPAA research requirements. It also violates informed consent requirements. Utilizing the questionnaire and conducting a prospective study meets the definition of research and uses PHI. So as we talked about, whenever something meets the definition of research or uses PHI, an HIPAA authorization is required. Our challenge questions are HIPAA has rules in order to protect a subject's privacy. How can information be further protecting by researchers in order to prevent any breaches of privacy? How can researchers recruit enough participants while ensuring that recruitment methods do not pressure individuals into participating? And de-identification is essential to HIPAA-compliant research. Discuss some de-identification techniques and the importance of ensuring that patients are not connected with their healthcare information. Those were our references. Thank you.